Before we successfully led the campaign to enact the ASFA Expanded Discretion law, ASFA already had some wiggle room. There was already some discretion that foster care agencies could use to decide not to file termination of parental rights proceeding.
What this did is create an additional exception to the requirement that parental rights termination proceeding must be initiated any time a child has been in foster care for 15 out of the last 22 months. The existing federal exceptions were that the child is in the care of a relative, or that there's been a specific showing that it would not be in the child's best interests for the parental rights to be terminated.
The third exception is if there is a showing that the agency has not provided services to help the parent reunify.
What the expanded discretion law did was add an additional exception that said that when parents are incarcerated or in residential drug treatment, or where they have previously been incarcerated or in residential drug treatment, and that is a substantial reason that the child has remained in foster care, then the agencies are relieved of the requirement of filing a termination of parental rights proceeding.
Part of their role, as they do with all parents, is to work with, engage, get to know, and assess families when there's an incarcerated parent. And that includes from the very beginning finding out where both parents are, doing a diligent search, and that should always include searching the correctional databases, local, state, and federal databases, thinking out of state too. Fathers should definitely be thought of. A diligent search should include both. And persisting in that sometimes a parent is in a corrections system under a different name, so inquiring of family members if they really going the full way to identify where these parents are.
What the ASFA Expanded Discretion law did was create this exception subject to certain requirements, and one of those is that the parent maintain a meaningful role in the child's life. It requires the agencies to perform a thorough assessment of the parent's relationship with the children, looking at all of the efforts that the parent has made to stay involved in the child's life, but also to talk to as many people as possible about the parent-child relationship, whether it be other relatives, attorneys, other participants in the court proceeding. And one of the requirements of the expanded discretion law is that the diligent efforts must include information to the parents about rehabilitative services, visiting plans, and other services that they can gain access to in order to reunify with their children, including services that might be available to them in the community after their release. Foster care agencies are required to provide incarcerated parents with a broad range of information about their rights and responsibilities so that they will be well informed of what their options are, as well as what the legal requirements are.
There are materials for caseworkers and for parents about the ASFA Expanded Discretion law, and OCFS has put out an administrative directive on it. They've also created posters for parents who are in prison, but I think it's important for caseworkers not to assume that a parent is getting this information from anybody else but themselves, because the posters were distributed, but whether they're actually posted in a particular prison, we really don't know.
An additional requirement of the expanded discretion law is the family services plan. This is a plan that's developed typically outside of the court proceeding. Family services plans are now required to take into account the special circumstances of incarcerated parents, and also the incarcerated parents are required to be involved to the extent possible in developing the family services plan, including, since it may not be physically possible for them to appear, doing this either through a video conference or through an audio conference.
ACS in New York has a saying, "Nothing about me without me," so you can't make a plan for a parent if they're not participating in whatever way is possible.
It also includes arranging visits, and this is so important. It's so important that it is mandated by the law, but arranging visits is critical to the child's well-being, to assessing permanency, and for so many other reasons. another legal responsibility caseworkers have is to keep the parent updated on the child's development, health, and education. And parents, including incarcerated parents, have a legal right to know about all these areas and actually to make decisions in them. Foster parents do not have the right to consent to special ed or certain decision making. It needs to be the incarcerated parent or the guardian. Beyond that, if they can also ask permission to cut the child's hair for the first haircut and involve the parent in things that the parent was probably doing before their incarceration and will hopefully be doing after. And I think something that is very important is really examining our own biases. We're bombarded with messages all the time about who is incarcerated. So when a caseworker receives a case thinking, oh my gosh, I'm supposed to work with a parent who's serving time for murder, we have no idea what that story is, and we have to think about that person as the child's mother and father, and then do our best to hold our assumptions lightly and find out what that means. There's all kinds of stories. Children love their parents, and it's our job to support that. And ideally, a caseworker would be able to process some of that with their supervisor. Their discomfort shouldn't preclude a child from having a relationship with their mother or father.
When a caseworker has a case where a parent is incarcerated, I think there's just automatically a huge barrier of being in contact. You can't just pick up the phone and say, I'd like to speak to, so-and-so mother in prison. Parents who are in prison can't just call any number. There's lists of who they can call. They have to call collect.
Once the parent has been identified and located, it's important to write letters to that parent to find out immediately. Every incarcerated parent is assigned a correctional counselor, currently called an offender rehabilitation coordinator, or ORC, who is a potential communication source and someone who might be able to facilitate a phone call between the caseworker and the incarcerated parent, or provide some information or updates also about what programs are involved are available inside the prison. And then every foster care agency really should have a collect call line that accepts calls from incarcerated parents, and should also be mindful that the parent is not able to call them in most cases. So letter writing is really important, and really going to see that parent whenever possible is really the best way to engage, get to know the parent, get to know the case, assess what's best for the child. In some cases it can be teleconference or even video conferenced. So all of those should be explored.
Really, you have to understand that parents' lack of contact often has nothing to do with their interest or wish to be part of the process. It really is that the system creates such incredible barriers that it's almost a miracle when a parent is able to reach someone on the outside.
So I can't emphasize enough the importance of visiting. It's sort of amazing that we even pose the question, because anyone who is a parent, and all of us were children, if we think about times that we were separated from our family, we wouldn't really question whether we would need to see the people who we love and who are closest to us. And this is so important for caseworkers to do. The barriers that they face are real in doing this because of the distances. But most caseworkers, once they do the visit, they realize the value and that it was so worth it to do for the child's well-being, for reducing the trauma of separation. Often their imaginations are so much worse than reality. And then you can't assess a family without seeing them together. So you can't read a note over here and a note over here and look at a picture and a picture and know what's happening. So you have to be able to see that family interact together. There's sometimes a myth that depending on where the parent is or the distance that means that the caseworker does not have to facilitate visits, and that's not true. Visits should always be facilitated at least bi-weekly, and then if that's not possible because of the distance, then on a monthly basis.
So one of the biggest challenges for case planners around the visits is just the amount of time it takes. Many agencies are trying to be creative, trying to find, is there a foster parent, is there a relative? Oftentimes case aides or admin people have been great at our agency.
Caseworkers can try to plan visits together if they can potentially take turns taking the children. In New York City, located within the child welfare system, is a program named CHIP.
CHIP is the Children of Incarcerated Parents program. CHIP facilitates visits between children in foster care and their parents that are incarcerated. CHIP transportation goes to correctional facilities in New York, New Jersey, Pennsylvania, and Connecticut.
But outside of that, there's bus services, van services, and foster care agencies, again, because of legal requirement to provide these, have to reimburse foster parents for that transportation cost. So it's always good to call the facility in advance and find out, just confirm, one, that the parent is actually there, including the morning of the visit, because parents can be transferred, while you're en route to that prison or correctional facility. So it's important to call in advance, find out what you can and can't bring, what the children can and can't have, what you can and can't wear, the hours, what documents do you need for the child? Do you need an original birth certificate? Is a letter on foster care agency letterhead enough? It might sound like, oh, that's a lot, but that's a lot less than making this whole trip and being turned away and then having to go back with everything you need, not to mention the trauma for children of getting all the way and looking forward to this, and then they're wearing the wrong shorts, or the caseworker doesn't have sleeves on their shirt. And caseworkers and foster parents need to also know that the end of the visit and what the child they see coming out of the visit may be a sad or even upset child because they just had to leave their parent, and that doesn't mean that visit shouldn't happen or the visit was bad. It's a completely healthy reaction when you have an attachment to someone who you have to say goodbye to. And in terms of visiting too, sometimes I think we put things in a sort of backwards order. So I've heard people say, well, when the child stabilizes in the foster home, that's when we're going to take him to see mom in prison. But that child may be not stabilizing in the foster home because they need to see mom in prison now. So remembering how important those relationships are to maintain, and keeping that in mind will make your job easier in the end.
It's important to stress that what the expanded discretion law does not do. First of all, it does not say that an agency may not terminate rights of an incarcerated parent. It expands discretion, it doesn't limit it. In addition, it doesn't change the grounds for termination. So in New York, one of the main grounds for termination of parental rights is permanent neglect. That requires an inquiry into whether the agencies maintain diligent efforts, but also whether the parent has maintained contact and planned for the future of the children. And there's a very important New York case that said that long-term incarceration and long-term placement of a child in foster care is not an acceptable plan, and that rights could be terminated for somebody who's serving a long prison sentence. The expanded discretion law didn't change any of that. It just says that the agencies are not required to move for termination.
Just as with every case, very careful case-by-case assessment needs to be done, and caseworkers should not feel tied by ASFA's time frame, the 15 out of 22 months. It's so important for them to look at the quality of the relationship, the efforts that the parent has made, the children's desires, and also what they have done. Have they abided by the law and provided the information that the parent has a right to? Have they given information about the rights and responsibilities? Have they provided visits? Have they given information about services available? Have they been updating the parent about the child's health, development, education? It's both looking at the family, but also looking at what they have done to support this family in reunifying.
I think the most important thing for caseworkers to know is that they're playing a really vital role in a child's life, and that they can be the agent that connects a child. And I will never forget, I went to a training by Barry Chafkin where he talked about a child who everyone believed had no contact with their parent, and the parent was not involved at all. And it turned out the child was in regular written communication the whole time and desperate to be able to see that parent. But since no one ever asked the child or inquired or spoke to the parent, no connection was made for years and years. And the joy that that child felt when they were connected with this parent that they have been wondering about and writing to for years, it's like you have the possibility to be that person. So as hard as it may be to be a case planner on even a good day, it's an important and critical role, and that, when you make that extra step, you could be offering a child and a family something that's life-changing.